name is Diana Shepard. I'm the editorial director of Divorce Magazine and a facilitator here at the Divorce School. Today's topic is entitled Mediation versus Litigation. Which should you choose? Part 2. And my guest is Marta J. Papa, who is also known as the Divorce Whisperer. Marta is a lawyer and mediator who is considered an authority on mediation nationwide. With more than 25 years of experience in mediation, litigation, and settlement negotiations, she has worked on about 8,000 litigated divorces and 4,000 mediated divorces. Welcome, Marta.
Hi, it's an honor to be here. Thank you.
Marta, can you tell us what qualifications should couples look for when choosing a mediator?
I'd say first, ask about that mediator's training and make sure they're an approved mediator, approved by a court or a Supreme Court or some regulatory agency. Second, I'd ask them, how many mediations have you successfully completed? Third, I'd interview more than one mediator, and I'd see who I feel is knowledgeable, who seems to be able to keep the playing field level, and who I feel comfortable talking to. You're looking for somebody who's non-judgmental because you're going to be bringing up lots of intimate information and details, and you want to feel comfortable with that person. Fourth, I'd look for a mediator that offers a flat fee for as many services as possible and a specific fee per hour for the time you are actually there in the mediator's office mediating. One of the big benefits of mediation is that it saves money, so you want to make sure you save money during your mediation. 5, I'd look for someone who specializes in divorce law so they can educate you about the law as it applies to your divorce. Even though the mediator doesn't give you advice, you need to do this or that, the mediator does give you legal information about your options and about the boundaries around your decisions. And so that's really important. And so you need to find a mediator that is specializing in divorce law. And lastly, I would try and find a mediator who has both a legal background and a therapy or child development background if your mediation involves children. That mediator is going to have both the legal information and, in addition, counseling skills that help the couple stay focused on the future and not on the past.
Can a couple mediate some issues and litigate others? And is there any advantage to doing this?
Yes, you can mediate some issues and litigate the things you can't agree upon in mediation. And yes, there's a huge advantage to that. It's a cost advantage. Like I said earlier, the fewer things that need to be resolved, the shorter the trial is going to be and the less money you're going to spend in trial preparation. So any agreements you can come to in mediation, they help lessen the number that the judge decides for you. And it also allows you to maintain control over the outcome of those issues and just take a few issues and throw them at the judge and you're sort of saddled with the judge's opinion on those issues. But the big ones you got to stay in control of.
If a divorce involves complex issues, can you still use a mediator?
Absolutely. An experienced mediator can handle any issue that a litigator can handle, such as valuing a pension. We do that in mediation all the time. Valuing a business, appraising real estate, valuing and dividing stock options or restricted stock units, dividing businesses, anything that you can handle in litigation, an experienced mediator can handle in mediation. I actually have a list of outside experts that I often offer clients to call upon when we need things done like valuing a pension or appraising real estate. I'm not a real estate appraiser. I'm not a pension evaluator. So I make sure I have those experts that are necessary for a complex divorce. And what's great about mediation is that husband and wife hire one expert, and they both talk to that expert, give that expert the information necessary, get to ask that expert questions, and then that expert comes to the mediation table and says, here's what I think your business is worth and why. And then they get to ask that expert questions or challenge that expert or have them use different numbers for a different evaluation. We don't have that luxury in litigation. In litigation, wife hires an expert, husband hires an expert. Now we've just doubled the cost, right? And they're both hired guns and go into court and testify against each other, and the judge decides which one he believes or takes something in the middle. So that is a very expensive process, a very time-intensive process, and again, the parties involved are not in control. When we use one expert and we use them in a mediation style, that expert answers to those parties, and we can use whatever kind of experts we need, and we save time, money, and maintain the control at our mediation table, which clients just love.
Can high conflict cases be mediated? What if the couple can't even stand to be in the same room together?
Well, high conflict cases can be mediated. You just need to find an experienced veteran mediator. You aren't going to want somebody who just finished their mediation training last week if you are a high conflict couple. Also, a plus is if you can find a mediator with a mental health or a therapy background, because those mediators are expertly trained on how to reduce conflict between couples while moving forward with an agenda. Personally, it was my inability to handle high conflict mediations that drove me back to school to earn a postgraduate degree in marriage and family counseling. My purpose was not to become a family counselor. Rather, my purpose was to learn the techniques family counselors use to decrease conflict between couples so that they can work on issues. And truthfully, I use those counseling skills more than my law school skills every day, whether I'm mediating or litigating in court. Those skills and theories I learned in a postgraduate education are the theories that drive marital conflict, and if I understand those, then I can help people decrease the amount of conflict between them. And so I use those all the time. If they can't be in the same room together, we call that caucusing, and the mediator can move back and forth between husband and wife. We call that shuttle mediation, also caucusing or shuttle mediation. I don't like to do that, though, personally, because it sort of breeds paranoia. Oh, what's the other person saying about me? I don't know what they're saying. And it doesn't teach the couple a different way of resolving conflict. Again, you're looking to a third party to help you resolve that conflict, and you can't do it yourself. And you aren't learning how to look your spouse in the face and say, here are my needs, and I see your needs, and now let's see if we can come up with a solution that meets both of our needs. It's not like that. It's I get this, you get that. If I get it, you don't get it. It keeps that competitive atmosphere going if husband and wife are not in the same room. So sometimes that's the only way to do it, and it's better than litigation. But it certainly isn't the preferred method because clients lose that extra skill of role modeling and learning how to resolve conflict between themselves.
You are a mediator as well as a lawyer. I am wondering if someone like you, who is a mediator who's also a lawyer, do they provide legal advice? If not, does each party need to retain a lawyer as well as a mediator?
Well, to answer the first part of your question, lawyer mediators cannot provide legal advice, period. It's against our rules of ethics to give any legal advice. However, lawyer mediators can provide legal information, and that's a fine line between legal advice and legal information. Basically, legal advice is telling someone what to do. Legal information is information about the law that anybody has access to, like on the internet or at a library, or they can read about that law in an article or a book. So to make it easier for me, to make sure I have given my clients all the legal information they need without crossing over the line to legal advice, I just download my state Supreme Court's website, my state's dissolution of marriage statutes. I print them out. I hand them to my new mediation clients so they have all the information about the rules, i.e. laws, that judges apply to divorce cases, and yet I didn't tell those clients to do anything. Part of my job as being a mediator is to be a purveyor of legal information to clients to help them understand how laws apply to their situations and help them brainstorm ideas about how to resolve the issues in their that they've come across in trying to get divorced. But their decisions need to stay in line with court rules regarding how to divide assets, parenting, and money in the future. So there's a difference between legal information and legal advice, and it's a fine line, and it's a hard one to stay on the right side of, but you can do it. The second part of your question asks whether a party needs to retain a lawyer as well. I think my mediation clients should retain their own lawyer as an outside expert, and I emphasize the word outside expert, not a lawyer to go to court and fight for you. In other words, they retain this lawyer to answer questions, double-check something, get a second opinion on something I've said in a mediation session. They just want to check it out. That's very different than hiring a lawyer to go to court and fight for you. So clients should spend no more than a few $100s on such outside expert lawyers because they're just using them for a few hours during the entire divorce process. And as you can imagine, some lawyers might want to take advantage of that case and run with it, wanting to make a lot of money off of this particular case. And I tell my clients to be really careful about the person that they select for this advisory role so they don't get caught up in that lawyer's spin or that consultant's spin on the facts and lose what they really wanted to do that they came up with at the mediation table. The worst thing that can happen for a mediator is that the mediator helps a couple come up with a comprehensive divorce plan, and then another lawyer who, frankly, is being unethical, there are a few of them out there, few of us out there, tries to tuck the client out of that comprehensive plan, promising some higher amount, child support or something, if they'll just let the client take it to court. And fear makes people jump into that net with that lawyer. It's fear that drives people to the biggest, baddest, meanest junkyard dog in the yard. And if in mediation I can help decrease their fear by giving them information is power, and keeping them in control of the decisions, I'm usually able to keep them away from those kinds of attorneys. You know, a funny, an unusual discovery of mine is that the clients who seem to have the most money, I work with a lot of millionaires, who can easily pay for outside counsel, those are the clients that typically say, I'm not going to pay lawyer Joe to give me his opinion in this settlement. I can read, I can add, I can see this is a fair settlement. I can see this meets my needs for the future. So why would I care what lawyer Joe thinks? And I just have to laugh at them and say, I think that's really smart. You don't have to hire lawyer Joe. I'm just telling you, if you want to, anywhere in the process, you have the right to. That lawyer just has a very different role than a lawyer that you would hire to represent you in court.
Marta, is it possible for a mediator to be completely neutral, or will he or she take sides?
Wow, that's a hard question. I hope that I am completely neutral, but I'm human. And I have experiences that I am reminded of when I'm listening to mediation clients talk. And I may have an opinion one way or the other about the issue that they're talking about. So, as hard as we try to stay neutral as mediators in our thinking, it's very difficult. But we absolutely can stay neutral in our actions. So everything that's going on in my mind, I don't have to open up my mouth and say it. I can be neutral in my actions. So by saying neutral in my actions, what I mean is that I treat wife with the same amount of respect as I treat husband. If I ask husband, what are your goals? Then I swing around and I ask wife, what are your goals? If I ask wife, what are your concerns? Then my next question is to swing around to husband and say, what are your concerns? And I don't comment on them. I don't say, well, that's not a concern, or, yeah, I can understand why you're worried about that. I don't comment on them because I'm not the judge. I'm not the arbitrator. I'm just there to facilitate resolution of disputes between husband and wife. So I'm just there to get the information on the table, get the parties talking about options and brainstorming new options that they haven't been able to figure out on their own, adding new information, and then help them negotiate. So in doing those things, I am neutral. I don't give one party more power. I don't give one party more kudos. I don't give one party more complaints. In my actions, I actually am neutral. And if I say anything by accident, which usually I'm not trying to be unneutral, but it's misinterpreted by a client, I strongly suggest that they call me on it. And so I'll give them permission ahead of time. If you think I'm helping your spouse more than you or siding with your spouse more than you, I want you to call me on it. And I won't defend it. I will apologize for it, and I will see what I need to do to correct the situation, because it's all in their perception. I mean, if I look at husband 2 seconds more than wife can take that as a blast against her, and I didn't mean a thing by it. So I let them sort of be the referee of me, which gives them power. They love that. And again, I say something or just look at someone a certain way, and their interpretation is that it's not neutral or it's not fair, and I want them to call me on it so that I can make it right. I can't make it right if I don't know what they're thinking. So I have clients do that all the time, and I'm so surprised at what they call me on. I think, oh my gosh, if you only knew, if you only knew. But I apologize. I make it right. I don't defend myself, and ask them if they still have enough trust in me to move forward, and we don't move forward until they do have that trust.
Marta, what can someone do to prepare for mediation? And would your advice be the same for litigation?
I think the best thing people can do to prepare for mediation is to focus on themselves. Again, self-determination. So instead of trying to convince the other party or get all their family members to agree with them, if they can focus on what do I need to move forward not being married to my spouse? What do I need to take care of myself and my children in the future? If they can stay focused on that, then they're going to make huge strides in very short periods of time with a good mediator. It's fear that interferes with their ability to mediate. It's listening to what other people said. Well, my mom said. Well, my sister who got divorced in Nebraska said. I heard this horror story, and all of that interferes with the mediator being able to do his or her job. So if they can leave all that behind, spend time just with themselves, focused on what I need, that's the best preparation, I think, for mediation. And I would say it's the same for litigation. If you have a lawyer who is listening to you and is saying, what do you want for the future? Not what I can get you, but what do you want? What's negotiable and what's non-negotiable to you? If you have good answers for those questions, then that lawyer can represent you to the best of his or her ability. Otherwise, the lawyer's just guessing about what you want, assuming you want the most money you can get and the most time with the kids you can get, when that's not really what you wanted at all. So being really clear with yourself about what your needs are. And sometimes I send clients, both litigation and mediation, to a counselor to help them get in touch with that. If they can't discuss and articulate their needs very well at the table and they sound scattered and they change their mind all the time, I'll ask them to take a break and in the action and go to a therapist where they can sit and be quiet and have no outside influences and really focus on what they need. And I'll send them to very specific counselors who know why I'm sending them there and can help them. They don't tell them what they want. They just provide the atmosphere where they can make those decisions and answer those hard questions so they can come back into mediation, which they do. They come back into mediation and they are clear and strong, and we're able to just zoom forward.
My guest today for this special Divorce School podcast on mediation versus litigation, Part 2, has been divorce lawyer and mediator Marta Papa, the founder of the Law Office of Marta J. Papa in St. Louis, Missouri. If you haven't already done so, we recommend that you listen to Part 1 of this podcast now to complete this session. For more information about Marta and her firm, please visit her website, www.consideringdivorce.com.